Welcome to the Stone Soup Group's presentation of part one of a series on compensatory education in a post-pandemic world. The return to school has been rolled out gradually in the last year and a half or so. The dust is settling a bit on that kind of beginning of that roadmap that the Department of Education has been talking about, that post-pandemic return roadmap. And now it's time to really think about what kind of education for students with disabilities was lost. What parts of their education that create that free, appropriate public education has been lost. Stone Soup Group approached me and we worked on a grant to get funding for a 5-part series that'll happen throughout the next 6 or 7 months. It will be based in person in 5 different locations in the state, and it will be about looking comprehensively over the ways in which comp ed can be used to reclaim some of that education that's been lost. Each part will be slightly different. This today, part one, what is comp ed, is intended to provide an overview, and then each succeeding part in the series will be about a particular time period or a particular type of kind of service area and so on. Again, looking at the denial of FAPE during COVID restrictions, school closures, loss of in-person instruction, and things like that. That's just to give you a kind of an overview right this minute of what you're tuning into. I'm Ann Applegate. With me is Brianna Bryan, and we're being facilitated by the very capable Marcus Douglas, who is the Outreach and Communications and Outreach Specialist at Stone Soup Group. Brianna Bryan used to work for the Disability Law Center as a special education advocate, really capable parent advocate, and is now the parent navigation specialist here at Stone Soup Group. So I'm really privileged to have some really great help to do this, and have a ton of respect for Brianna's experience in special ed, both as a parent and as an advocate. What we'd like to do is first, who are we and how did we get here? I mentioned Ann and Brianna and Marcus. We were lucky enough to get the opportunity through Stone Soup Group, which is the parent training and information center for Alaska under federal law, funding through the Mental Health Trust Authority. We got a partnership grant to do all of this work. So really grateful for that input. We have people in the room, generally speaking, and also online. And the way that we're going to do this is as a webinar because of the nature of some of the information that gets conveyed when we're talking about students with disabilities. We're often talking about children. Because it's a statewide reach, there doesn't take a lot sometimes of information about a particular circumstance for somebody to be able to identify that child and that family. So we don't want that to happen. And so we're going to treat it as like a webinar, which means that we'll take questions off of the live stream format. We'll take them more as a question and answer, so we can modify our answers to make them generalized. And we want to avoid exposing the identity or the disability status of anybody. And I've already kind of said what this series will but I want to make sure that you know how to find it and how to use it. The recording will be available online a week or a week and a half or so after we have done the live stream. It will be available so that you can review it, because each session will provide additional information. It's not going to be a repeat of one thing 5 times, or repeat 4 times, I guess. But what I really want to do is to break things down into what I call actionable intel. news you can use is what we also used to call it. We will offer the in-person in 4 other hub communities. Our next visit will be in Fairbanks. We'll be talking about the sort of the beginning of the education process for developing an IEP from child find all the way to that first meeting. And we'll be doing that both again in a Zoom and in Fairbanks. And to find out where and when, you should go to the link for trainings and events at Stone Soup Group. And also, please register if we're going to be in your community. We would love to be able to help you in an in-person roundtable discussion with other parents. Terminology and acronyms. Something I always say about with special education is that it's alphabet soup. And a lot of you probably will know what these acronyms are because you've already been a parent advocate in this world. But what I will try to do is start by using the phrase and also use the acronym. After I've done that a few times, I'm going to revert to acronyms because in this area, those acronyms have taken on the status of nouns. They just are the name of stuff. Like when I say FAPE, it's free, appropriate public education, but courts call it FAPE, schools call it FAPE, reports talk about FAPE. FAPE, the most important part of it is appropriate. The second most important part is free. So the rest of it is just a lot more language. So I will call it FAPE and things like that. Terminology, I will try to use student. I don't like to say kiddo and kid because it seems too informal for something that's this serious. I also don't like to say child very much because child is a particular kind of age. If it matters, I will describe it. I'll say infant or toddler or young child, pre-adolescent, adolescent, youth in transition, young adult or adult. Otherwise, I'll try to say student. If I refer to you as a parent and you're not, know that I am including guardians and any other recognizable educational decision maker. Today's agenda: what, why, and how much of compensatory education. Again, generally speaking, a lot of these subjects we will handle in more detail in the subsequent series parts. So we were going to talk about those things. And then we're also, before we talk about questions, I'm going to go through the big question, which is, does this crazy worldwide pandemic, COVID-19, and all of the uncertainty that we had in the beginning about how it's even spread and what happens in schools and vulnerable populations, we're talking about, kids with disabilities who often have co-occurring physical impacts that make them more vulnerable to COVID. After all of that, does the IDEA change? Is it different because of the severity of this world crisis, this impact? And we'll talk about that and what the federal government says. I have to say my proviso here, which is that while I am a lawyer and while my training is in disability rights, especially special education, I won't be giving legal advice today. I can't talk about specific problems that people are having with their specific cases and talk about their law because I am not a practicing attorney with support from a law firm or from my own firm. I work now as a consultant and I don't do the active practice of law. And so you shouldn't take anything I say as sort of actionable legal advice. I'm giving information. So what is compensatory education? It's a remedy owed to students with a disability who have been denied a free, appropriate public education. That's that FAPE thing, right? It is not in the IDEA. Compensatory education, you could do a word search in the code or the act and not find it except maybe in a footnote. And you wouldn't find it in the law. It's court created. What it is sort of described as generally is a quantity and type of special education and related services that are intended to catch a student up on expected progress that was denied because of a lack of services and a lack of FAPE. One of the new clarifying statements from the Department of Education is that it's not just a denial, but it's also an inability. It includes an inability to provide services that result in a lack of FAPE. So they're intended to remedy a loss of educational opportunity. So you would ask, kind of generally speaking, what position would the student be in but for that denial of FAPE, or what is essentially a violation of the IDEA? And so why did courts add it? Because it's not in the IDEA. Congress didn't anticipate any kind of remedy. In fact, money damages are not part of the IDEA either. So people don't, if there's a problem with a violation of the IDEA, it's there, you don't get like some kind of damages award of $3,000 because your student didn't get a month of speech language services that were in their IEP. But courts realized that without some consequence, there would be no guarantee that schools would provide appropriate individualized education and related services. And even worse than that, there would be an incentive for delay. The idea that there could be a complaint from a parent that something was inappropriate and they would maybe use their dispute resolution avenues and file for a hearing and get a stay put, which we can talk about later in the series. And that in that time, there would be no services except for that inappropriate IEP. And there would be no reason for the school district to not try to resolve that quickly, because there would be no comp ed for the time that was lost in between the start and the ending of that dispute. So accountability for actual benefit is another really important part of the IDEA. It's a results-based criteria, right? We look at what benefit has resulted from special education when we're deciding whether or not something is appropriate. So courts said, not just lip service, not just hours, or even looking at effort. Comp ed allows us to focus on a result-based criteria for deciding whether or not an IEP is appropriate and the implementation has been appropriate. When comp ed might be due is again related to a denial of FAPE. FAPE is kind of a substantive thing. It's not a procedure that's followed and they can check the box and say they did the notices right and the timeline is right and we have an IEP that fills in all of the things on those pages that are supposed to be there. It's about a denial of appropriate education. And it comes up in a lot of complaints, a lot of circumstances where things are not working well. There is an obvious denial that could result in a comp ed claim. But there are some that are just more frequent than others. And I'm going to talk about what those are as a list here. I'm going to go over them lightly. And then again, those next 4 series, we're going to talk about them in more detail because it's a huge, huge subject. It's like saying, how can anything go wrong? And so we have a lot to cover. But the statement of a loss of FAPE currently under Andrew F. is right here on your screen. And that's that the substantive obligation under the IDEA is that a school has to offer an IEP that's, quote, this is what your big money sentence, reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. And it's further modified by the statement that every child should have the chance to meet challenging objectives. So this is the standard of FAPE, that schools and school districts have to meet ever since 2017. And this is the Supreme Court. So even though there was a difference among the different circuit courts in the country about what that standard was, we used to have a de minimis benefit. So that's something more than nothing in some circuit courts. And in the Ninth Circuit, we had different statements about meaningful benefit, that there had to be meaningful benefit from the IEP and from the implementation of that IEP. This is now the law of the land. The Supreme Court has spoken. So examples that are where you would most frequently find comp ed being due, certainly a violation of child find. And child find obligations are a whole host of things that the school has to do. So we'll be talking about that a lot. The failure to review an IEP. I've said it a couple of times, and now I'm going to say individualized education program. From now on, IEP means the program that organizes all of the individualized special education and related services and accommodations that a student gets. But failure to review that IEP annually, or when circumstances warrant a new meeting for review, that's going to be a place where comp ed might be due, depending on how long and how much the school district did and didn't do. Failure to offer an appropriate IEP. We have seen that a lot during the COVID pandemic. What we saw even more was the failure to implement an appropriate IEP. And those would be a denial of FAPE, and comp ed might be due in that circumstance. And there are some procedural violations that are considered a denial of FAPE automatically, because the procedure is protecting some part of the process that is just so important that in the absence of that part of the process, there cannot be an appropriate education. And we'll talk about what some of those most common procedural violations are in a couple more slides. So this is kind of an overview of where you're most likely to see a comp ed award, but they show up in lots of other places too. It's not by all means the only thing. What's important to know about child find, and it is what it sounds like, you got to find the kids. But it isn't just that initial identification. But that is, of course, one of the most important things. So to comply with their child find, to meet the child find obligations, the school district must find all children with disability and identify, locate, and evaluate and provide FAPE in a timely manner. There are timelines. And they have to also act on referrals by parents or by any other professional. But a violation can also be the failure to evaluate already eligible students in all areas of suspected need. Now, this is particularly important in the context of what we're talking about here, when COVID-19 gave rise to additional areas of suspected need, whether it was the disruption of a plan for education, which certainly happened, or whether it was about the strain and stress on families and on individual students that gave rise to increased levels of need or additional needs that weren't previously being served. It was a time of a lot of upheaval, and kids were upset too. Besides having just changes in their education services that made their existing progress become stagnated and then result in regression. One of the ones that comes up a lot is the prolonged use of responses to intervention. That is true. That was true before COVID-19 pandemic, and is certainly true now. What we would want to do is talk about that. That's its own subject, and it will be part of the next session in this series. Next part 2 is going to address include responses to intervention. The standard for suspected need is that the school knows or should know of a need for modified curriculum, specialized instruction, accommodations, and or related services. So that goes to the RTI issue. Some of the further tiers of intervention, the greater levels of intervention in RTI start to look a lot like modified curriculum, start to look a lot like specialized instruction, and certainly related services. You start to see pullouts, and they're seeing a reading specialist, and they have they're altering the timelines for expectations for assignments. They're changing the way an assessment looks. In those later stages of RTI, we're really talking about special education that hasn't been identified and gone through the process of the IDEA would require. That would be a violation of child find and might well result in compensatory education due. A violation can also be a failure to reevaluate after a parent request. Parent identifies a new need and there's no response to that, or it's not timely, or there are follow-up assessment timelines that are missed. That would still go under that child find obligation. Procedural violations that deny FAPE. The one that is per se, no question, a denial of FAPE is always the denial of parental participation. And there are all kinds of ways that can happen. It can look different, and sometimes can seem like it's not really a denial of FAPE, because there haven't been significant changes in what is an already appropriate IEP, and it's just a matter of amending a little something, and if the parents didn't participate, that's still a denial of FAPE. Just is. The IDEA is repeatedly discussing the pivotal role that parents have, not just as safeguards of the process and eyes on as the advocate for their child, but it's also because parents are really important as a source of information at that IEP team meeting. Who knows that kid better? So the IDEA refers to parents as safeguards of the process, as advocates for the child, and as an important set of experts. They are experts on the student, the entire child, including in that educational environment. So one of the ways to deny parental participation is to not allow them to have important, true, accurate information, timely information. Misleading reports on evaluations or a failure to provide all the evaluation reports to parents happens. It happens unintentionally, and it happens because teams are trying to avoid having that report be part of some parents' advocacy on behalf of their kids. That is a really important piece of the comp ed that can arise from that kind of procedural violation. Failing to have a general education teacher at an IEP meeting is an automatic denial of FAPE. And the whole reason for that is that the purpose of the IDEA in its infancy was to prevent desegregation, to make sure that to have a general education teacher at the IEP meeting is to keep the eyes on the prize. That what we're looking to do is to create an educational program that allows, with proper supports and services, that allows that student the closest approximation, nearness to their age peers in the general ed environment. So not having that teacher there is basically saying, we're not even going to consider segregation or desegregation, integration with the general school classrooms. So that is just a per se denial of FAPE. Failing to provide a meaningful opportunity for parent involvement in the IE process, that's a little different than the first bullet point here, because what this is about is the meetings. Especially during COVID, not providing an opportunity for parents to be there because it's not a good time for them, because they're ill, or because there is illness in their family that they're addressing, because they are being caregivers and educators with remote learning. Making sure that parents' schedules are the primary mover for the setting of the meetings and the duration of the meetings, and that there's flexibility, that a parent that doesn't have the technology available to them to do a remote IEP has access to the tech somewhere, somehow. Those are all things that the failure to do that, to work to make sure that parents are at these meetings and can be, that's a violation that denies FAPE. To recap, all the things that we're talking about are just the yes or no about whether or not comp ed might be due. We're still not talking about how much. And that's a two-part analysis. So we're looking at the first part. So some other ways in which FAPE can be denied is a failure to offer an appropriate IEP. There is a science-based justification for or foundation for an appropriate IEP, but it is also an art. The threshold question is whether the school knows or should have known that the IEP is inappropriate. Appropriate means that it should be reasonably calculated to provide benefit in light of the circumstances. That's that Andrew F. standard that we were talking about. It should be based on evaluations across all areas of need. And the IDEA requires that it shouldn't be one single evaluation. That for an informed decision about areas of need and to create appropriate goals and objectives, there has to be more than one perspective from an assessment. It can be that there's an observation component, or that some of the testing is done from reporters and parents and teacher and even student as students get older, that there are different kinds of evaluations and they need to be applied. Of course, it's individualized. That IEP, to be appropriate, should have measurable goals and objectives, and we can talk about that later. It has to have an explanation of what the least restrictive environment is in this IEP, a justification of why that is the least restrictive environment. And a least restrictive environment doesn't have anything to do with physical mobility in a space. People always think, well, restrictive, that means that the student can't move. But that's not what it is. Least restrictive is defined as the place where the student would be, but for their disability. What is the closest proximity to that environment with appropriate supports and services? How close can we get them to being integrated with their age peers? So the other parts, which, if you have an IEP for a student, those parts are all dictated by the law. The profile, if it's the appropriate, then a transition plan and transition services, a statement of the accommodations, a statement about what kind of statewide assessments they'll be taking. And there are other parts as well. But the failure to offer an appropriate IEP, if you can demonstrate that the goals are not measurable, and the objectives are not related to the goals. That would be an inappropriate IEP, and Comp Ed might be due for the period in which that particular set of goals and objectives were not appropriate. Failure to implement the appropriate IEP, and everybody knows that that's the bulk of what happened during the COVID pandemic. We had appropriate IEPs, or maybe we didn't, but regardless, the implementation of the IEPs that required particular placements, particular sets of services and ratios of student to teacher, and behavior plans that were about moving through a population of people face to face, all of those were impacted by COVID-19 restrictions. And that part we are going to pick apart in some of the other series, because it is where that bulk of that compensatory education is going to come from. So what you end up looking at is first of all, hours. This is something that we saw a lot, is that reduction of the time spent in education. We also saw the change in personnel. We saw people without the right qualifications that were trying to deliver services, aides, people who were not specialists for related services that were trying to provide those specialized services. If somebody should be supervised, was the supervisor properly qualified? We saw that. We also saw curriculum issues. When you have something like reading fluency goals that would be appropriate, and they're not vocabulary, but then the modified curriculum is entirely focused on word meaning, that's a failure to implement an appropriate goal. And we saw that kind of thing too, as students with a particular specific need were lumped together with other students who had a particular need, and they weren't the same. We've said it again and again, a placement is not a place. It's a suite of services. It is about the ratio of adults to students in a place. It's about what kinds of things are available in that place, whether we're talking about physical resources like computers or iPads that have software that allows for communication, or spaces that are distant from one another so that you can have some cool down areas. That is a place, but it's more like a description of an area in which things can happen. If the placement is changed for more than 10 days, that's a change of placement. If that's done without a meeting of some kind that parents are involved in, that is called a unilateral change of placement. And that happened, right? We had change of placement because there were shutdowns of schools, and then there were difficulties with having the same people in close quarters in a classroom. So that change of placement is a denial of FAPE, and there's a Comp Ed claim. How much that is or how little that is, we don't know, but it certainly should be addressed with a compensatory education finding. Changes of setting, that's basically whether somebody's in kind of the neighborhood school like their siblings who don't experience a disability. Are they at home? Even if the school district is providing all of the same suite of services, placement hasn't changed because somehow they're able to provide everything that was in that IEP. Maybe it was a home-based IEP. If the setting has changed, if they are no longer offered extracurriculars at the school, or to do physical education with age peers, something like that, that's still a change that probably rises to the level of a denial of FAPE with regard to that service. Accommodations, same thing. And related services, absolutely. The beauty of related services, when there's a gap in providing those services, there often is a very clear amount, not just that there was a denial of FAPE, but the amount of comp ed is clearer because of the discrete time that and the hours that are provided for in related services. It makes it a little bit clearer for the demand. How much compensation is owed is a question that arises after the existence of a denial of FAPE has been established. They are related questions, but not in a kind of one-to-one kind of comparison as you might expect. Again, going back to our discussion or my mention of related services are easier because they're often done in a pullout, and they're often one-to-one, and they're often done on a routine basis for a certain amount of time. Tuesdays and Thursdays, an hour of speech language therapy with a student being pulled out of a class. If they miss 3 weeks of that service, we have a pretty good idea about how much education or related service is due to compensate for that opportunity lost. How much compensation is owed is the second part. We've already decided that yes, there is a denial of FAPE in one of those other categories or in some other detail that we didn't cover yet. As you might guess, and as I sort of alluded to, there's a difficulty in quantifying how much compensation is owed, even when we know the duration of time. Say there's a parent has made a kind of a request, I guess I would start with that way, for the IEP team to review the appropriateness of a couple of goals, or there's been an implementation gap that a parent is clearly looking at. And we know that the implementation stopped in March of 2020, and it wasn't started again until October the following fall. And so we know the period of time. We even know kind of what the services were, or what was denied in terms of the placement. It's all been remote, and parent has been standing at the computer and trying to help the student do their education. So we know all that, but it isn't just about time. And the courts have taken their authority to grant any relief necessary and have said all kinds of things, and these are some of them, that the student is entitled to a compensatory education period equal to the period of deprivation. Now, that, I mean, we kind of know that's a sort of about a calendar or the hours of the day. But when we talk about deprivation, what does that mean for a student who was in a classroom where they were, say, in a general ed classroom, and they had an aide that was helping them to with modified curriculum, but the curriculum was also being done in the general ed environment. And maybe there have two students who are both working together at the same pace. And so individualized learning is being benefited by the presence of two people in the aid. What is that deprivation? What does that look like to repair that? That another court says, well, it's not one-to-one hour counting, but we're looking at reasonably calculated amounts to provide the benefit of the education missed. So again, using my example, what does that look like? Another court decided that because we were talking about equitable remedies, fairness, that we also could look at the actions of both of the parties involved in the dispute. And they said that where a parent has refused what they think are appropriate services, and there's a delay, when those services are found to be appropriate, we can reduce comp ed by the amount that was resulted from the delay caused by parents' refusal to accept those services. That sounds kind of on its face to be fair, but appropriately, this is disfavored now because subsequent courts agreed that parents are not experts, and they shouldn't be held to this standard of of knowing that something is appropriate or not appropriate. So if they're refusing, in good faith, refusing to accept services, and then there's a period of dispute, so there's a stay put with those inappropriate services from the parent's perspective, denying them comp ed completely for that time period is an unfairness that operates against that child. That is now part of the consideration, but it really doesn't reduce the whole period of time or the intensity of instruction for comp ed. Another judge thought that it should be reduced by the school district's reasonable efforts to respond to a complex problem. Now, of course, devil's advocate, I would say, so we would reduce it by some more futzing around to find something that would be FAPE, even though they've already, that's the part of the problem, is that there's been a failure to provide FAPE. So now there's a continuing failure, and we're going to reduce the comp ed by that, what we would describe a reasonable effort to respond to a complex problem. Fortunately, that is no longer really, it's another kind of disfavored part. And what really practically ends up being the kind of creation, it's an argument, right? And what the argument is based on is a combination of time and services lost. So looking at stuff that's sort of building blocks concrete, like who was there instead of the specialist, what was the effect of not having somebody who was supervised, the time lost, the number of students to professionals ratio, those kinds of things that are clear. And then looking at the impact on expected progress. And expected progress is about creating a timeline of the deprivation and looking before that timeline and looking at after that timeline. What's the current level showing? What are the current levels showing? Looking at a baseline, looking at what the student has accomplished before the deprivation, and then there are other special considerations. And a good example of a special consideration is if you're talking about, again, going back to speech language therapy, and if you're talking about a student who's between 3 and 6, a 1-to-1 loss of speech language time will not appropriately compensate for lost services in that time period. There's even a great court case somewhere. I can't remember where it came from now in my cluttered case brain, but it basically says that when you're talking about that hugely important window of language acquisition and speech and preparation for other things like reading, that a 1-to-1 loss that you're going to try to compensate for when a student is 8 or 9 is not sufficient. It's going to take more work to compensate for what was lost by that same amount of time. That's a special consideration. I'm going to do a little side alley here, a little sidetrack, because I want to make sure that we recognize that compensatory education is different than extended school year eligibility. Really, sometimes closely confused, but the standards are different and matter. So I created this little chart here, and I think maybe I'll try to do some highlighting. Will that work? Oh, it's a little delayed. I'll try. So comp ed, we've talked about, is a remedy for a past denial. And ESY eligibility, going down that same column, we can find my little arrow there, is forward-looking, and it's about preventing something that we suspect might happen. So very important difference. With comp ed, the thing that's happened, again, second column now, the thing that's happened is a denial of FAPE. But with ESY, what's happened is we have an expectation of regression that's going to happen over school breaks. That's not going to be recouped within a reasonable time when school is back in. Or there's a lack of progress, a significant lack of progress during the regular school year that's going to impact independence as an adult. If we have someone whose needs are intensive enough that their lack of progress is going to result in increased dependence for housing, for feeding, for other like activities of daily living, that person is eligible for ESY, extended school year services. Also, if there's a new skill that's been acquired just before that break, and there's a fear that it won't be retained and they'll have to start over again at the beginning in the fall, that's another sort of circumstance which justifies ESY eligibility. So they're really different. You know, one's forward-looking and one's really looking back at a denial. There are some similarities in how you calculate what is owed, and that's really where the overlap ends up happening in people's minds. But how we show it happens for Comp Ed, they prove the failure to provide that appropriate education. For ESY, again, in this third column now, you have to look for a past pattern of regression. Now, where you look is the same, which is you look to progress notes, in-class assessments, evaluations, and I have my acronym them, IEEs, which is the Independent Expert Evaluations. What you want to look is a before and after the break to look at screenings or evaluations and look for what might happen. What's the probability that there's going to be this regression that can't be recouped? So what is owed in each of those circumstances? For Comp Ed, we've been talking about it. It's additional education and related services to get them where they would be, but for the denial. But for ESY eligibility, what is owed is education and related services over those periods of breaks where the regression would be taking place. And it's to try to retain, kind of hold back that regression so that the school district and the school is not constantly trying to make up for the time that they've been missing their education. If you spend the whole year trying to recoup what's lost in the summer, you're making no progress. That's ESY. And then how much is owed? For Comp Ed, it's the amount that's reasonably calculated to result in catching them up. So you do have to show the rate of progress and show the times missed. For ESY, it's the amount that will prevent the regression that's anticipated during that time. It's not summer school. ESY is not summer school. ESY refers back to the IEP, the individualized need for retaining gains made through those goals and objectives. If summer school is an appropriate place to do that, awesome. But it isn't just summer school. Now, for Comp Ed, you can use extended year services as the time and place and placement to have the award of the Comp Ed. What I want to remind you is that the standard is different for Comp Ed because Comp Ed, once you prove that there's a denial of FAPE, they have to reasonably calculate how to make up for all of the Comp Ed that was missing. ESY eligibility or ESY services are based on that pretty good IEP standard, which is lower, I think. How to deliver Comp Ed. Think about it for a minute. You've got a student that goes to school for however long a day that is. And then you have to figure out how to deliver compensatory education in such a way that it's going to be useful. So the law says that it must be in addition to current IEP services. So it's possible that you could do it within a general ed portion of the day, But I would say that that's just compromising that portion of their education. So it kind of has to be outside of the school day. I already mentioned that the standard is different than IEP services, right? It's not that pretty good IEP, pretty good implementation. It is making up for everything that was lost, something that's reasonably calculated to do that, to accomplish that catch up. So outside of the school day, the school week, or the school year, and as an advocate for parents and families, I used to, when we got to the point where we were talking about, we'd already proven the denial of FAPE, we'd probably negotiated or gotten a decision on the amount of comp ed, and then we would work on what was their student like? Is the student a morning person? If so, we could do a 0 hour. Would it be the kind of service that was going to be delivered to compensate if it was something that could be seen as play fun, like OT, occupational therapy or physical therapy? Might it be something they could do on a Saturday morning? It would feel like a playtime. I had a client that had such a huge deprivation by a failure of child find from the time they were 3 until they were 6, only getting speech language therapy once a week when they were clearly very impacted by autism. We had such a huge comp ed and a comprehensive comp ed award. The denial of FAPE was across all areas except, even speech and language. So the family wanted some additional things during the school year, but what they really wanted, not knowing anything about autism and wanting their whole family to be part of it, was to have some family-based learning in which their student could also have make up for the lost education. And we ended up creating access to a summer camp that was a multiple week family summer camp that was designed for young students with autism and their families to learn cooperatively and with other families. And it was something they did for several years in a row. It worked for them. That's the thing. So thinking about before or after the school day, on the weekend, what about winter, spring, summer break? Again, not summer school per se, but if summer school works, great. And extended school year services, again, what's nice about extended school year and summer school is that lots of comp ed is about, creating an educational environment where somebody can be integrated with other students their age. But considering the impact on students and families, again, if you're going to a hearing or to a court, the judge can craft something that's even similar to what we were talking about with this camp. They have a lot of authority to change the award. So now pivoting, we've talked about denial of FAPE and how much comp ed might be due. And now I want to pivot a bit to what we saw as professionals and advocates during the pandemic shutdowns, so that you can start thinking about similarities in your own experience and recognizing where you would see a possible claim for compensatory education resulting from the shutdowns and the restrictions when we came back. So we did see inappropriate IEPs developed or more inappropriate amendments. And definitely the delivery of services that were shortened or didn't have appropriate staff that were doing the services We saw that, but we saw a lot more of the change of placement and not having the least restrictive environment, because proximity was potentially dangerous, and we didn't have a lot of understanding initially about how it was even transmitted. COVID posed real challenges for schools and for families about where their student would be educated. And we saw that a lot. We heard about it a lot. And the result of that was a unilateral changes of services. School districts just, saying, this is how we're going to do this. Partially it'll be remote. Partially there'll be 3 kids in a classroom that are 8 feet apart and masked. We'll do one-to-one, but only with certain kinds of controls on exposure, all kind of, responding as best they could within the limited information that people had. We also really saw changes in staff, who is doing what, whether they had the requisite expertise or the credentials, and even numbers, ratios of adult to student. But keep an eye out for those other things that had to happen. They were supposed to happen anyway. An annual review, progress notes that were on time and reflected real classroom, or not classroom, real education experiences, timely follow-up meetings, parent participation in the IEP development. That goes back to that top one, the inappropriately developed IEPs, but also making sure that parents had information that they needed to decide if an amendment to the place was appropriate, if there were other options. We saw that as well. And then huge gaps. And I want you to pay attention when you're thinking about your own student to the development of new areas of need that were the result of both COVID and the responses to the pandemic. New areas of emotional need, areas of need that arose because of services not being provided. It isn't just then that the service wasn't provided because that was due. It's also that not providing, for example, behavior interventions and real-time education and support for behavior that's about reinforcing particular strategies and particular outcomes. That is owed, is a given. It didn't happen, it's owed. But out of that developed additional needs for services. So pay attention to that. And the way that I would say to deal with that one is to make sure that you've got current evaluations that are across all areas of suspected need. Make sure that you can get data about some new area of need if you believe that there is one. One of the things that we heard during the beginning of the COVID restrictions was that school districts cannot be expected to provide compensatory education because it will break the bank. It will shut down all education if schools have to provide FAPE or have to make up later for not having provided FAPE. There has to be a waiver system. We heard a lot about school districts going to have to go to the U.S. Department of Education and request specific kinds of waivers of their obligations to provide compensatory education. And we were, as advocates, we were concerned that that was going to happen. And there is a waiver process, actually, that already exists in the IDEA for states to tell the Department of Education that they can't maintain their current level of effort. It's called maintenance of effort. And it has happened for states that have budget crises that they didn't anticipate. So we were afraid that there were going to be requests for waivers based on the inability to provide compensatory education for special education. So when the guidance came from OSEP, the very first one in March of 2020, we were encouraged. They said the IDEA is the same. If FAPE was denied, Comp Ed is due, period. And then they gave examples. They produced a short webinar. And this is a verbatim, I copied and pasted these statements because I thought they were so significant. If an initial evaluation, eligibility determination, or development or implementation of the IEP were delayed, Comp Ed is due. If the method through which services were provided, virtual or hybrid, were not appropriate to meet this child's needs, Comp Ed is due. If some or all of the child's IEP could not be implemented using the method of service delivery, Comp Ed is due. If meaningful services to facilitate transition from secondary school were not provided due to the pandemic, Comp Ed is due. And in fact, it's due after the student ages out if it occurred before the student aged out. If a child's behavior was the direct result of an LEA, that's the district, local education agency. If the LEA's failure to implement the IEP and the child's education was disrupted because of that failure, then Comp Ed is due. This is the link. The U.S. Department of Education put out guidance in March of 2020. It was a very quick and dirty Q&A, and it's called Questions and Answers on Providing Services to Children with Disabilities During the Coronavirus Disease of 2019, or the 2019 outbreak. And one of the quotes that I thought was most relevant: if a child does not receive services after an extended period of time, a school must make an individualized determination whether and to what extent compensatory services may be needed, consistent with the applicable requirements, including to make up for any skills that may have been lost. So somebody asked earlier about making the case for a life skills student about for the need for Comp Ed. It is, yes, skills that have been lost, but also the extent of the period of time and the type of services that have been skipped. OSEP is the Office of Special Education Programs. That's another branch of the U.S. Department of Education. So it speaks with the force of the federal government. And there is the link. It's also a Q&A, and it is from September of 2020 for Part B services. OSEP reminds SEAs and LEAs that no matter what primary instructional delivery approach is chosen, SEAs, that's the state, LEAs, that's the district, and individualized education program teams remain responsible for ensuring that a free, appropriate public education, FAPE, is provided to all children with disabilities. If state and local decisions require schools to limit or not provide in-person instruction due to health and safety concerns, SEAs, LEAs, and IEP teams are not relieved of their obligation to provide FAPE to each child with a disability under the IDEA. That Q&A goes on to say that if they have to do that, then they need to provide Comp Ed to make up for what was missed. OSERS is the Office of Special Education and Rehabilitative Services. It's another branch of the U.S. Department of Education, and they came up with their own guidance. This is a little more current even. It is from 2021, so a year after the last one. The U.S. Department of Ed is still saying the same thing. Now, this return to school roadmap is 40 pages long, and it's very detailed, and I would recommend, if you can print it off at home, do. You should have it. It should be something you walk in the door with to your IEP team meetings. Here's the biggest quote that I thought was good. During the COVID pandemic, LEAs have reported difficulty providing services. I'm summarizing this kind of quickly. Some students may not have received appropriate services to allow them to make progress anticipated in their IEP goals. So that's guidance about pointing to how you would demonstrate how much comp ed is due. It will be critically important for IEP teams to make individualized decisions about each child's present levels of academic achievement and functional performance. That's that profile we were talking about, and determine whether and to what extent compensatory services may be necessary to mitigate the impact of the COVID-19 pandemic on the child's receipt of appropriate services. Take that quote, take this document in, and say to that IEP team, this is all great. We have our PLAF, our present levels of academic achievement and functional performance. It's right here. Awesome. We also need to look at how we're going to compensate for the denial of services that occurred during school closures and during limited access to in-person learning. OSER is the Office of Civil Rights, also a branch in the Department of Ed, and they came up with their guidance. Again, these are basically all of the offices of the U.S. Department of Education that are looking more specifically at their area. So OCR is particularly charged with rights under Section 504, but FAPE for 504 purposes is the same as FAPE for under the IDEA. Compensatory services are required to remedy any educational or other deficits that result from the student with a disability not receiving the evaluations or services to which they were entitled. That's super clear. But the next session, we're going to look at compensatory education when we're talking about everything from child find and referral all the way to the beginning of that IEP meeting. So including notices and things like that. And I think I've listed them off. Yes. So we're going to look at child find, referrals, response to intervention. We'll look at evaluations and reevaluations, because reevaluations has the same sort of obligations as evaluations, and also independent expert evaluations, and what the process is for getting those independent expert evaluations. We'll also talk about the evaluation summary and eligibility report called the ESER, looking at what should be in an ESER, how parents should be informed about what the reports are going into the ESER. What has happened in the past is that parents are just given the ESER and they're not given any of the supporting documentation that is contained in the summaries. And also what an eligibility decision should look like. And notices and other procedural safeguards. And then convening that IEP team meeting, looking again at sufficiency of opportunity for parents to participate and the role that parents have, not just as safeguards, but as information sources. So we're going to talk about all that, and we're going to really look at it during pandemic restrictions, whether or not there are places in among all of this process that people have really experienced a denial of FAPE because of failure to provide the necessary parts of all of these things on the part of the school district. Really going to be looking at remote services and the impact of school shutdowns. Contact your navigator, your parent training and information center parent navigation system is at work, and we'll do what it takes to make sure that you get the information that you need.